Preserved for the record. Offense variable 11, there was no sexual assault. That does not apply. Do you all agree?
Yes.
And offense variable 12 also doesn't apply. Do you all agree?
Yes.
Offense variable 13, there's no evidence that this was a continuing pattern of behavior by Mr. Rimson. Do you all agree?
I agree. Yes.
Offense variable 14, scored at 0 points for the offender, a leader in a multiple offender situation, scored at 0.
I think it's correctly scored.
I agree. Mr. Woodard, do you agree it's correctly scored at 0?
Your Honor, I believe it should be scored at 10 points because Mr. Rimson had direct day-to-day control over Emmanuel, which was sort of distinct from Ms. Foster, the other defendant. So I think in that circumstance it would be appropriate.
Okay, well, I disagree. I agree with Mr. Brown. Although he didn't articulate his reasons for his argument, I think that it's clear to me, based upon the evidence that was presented here, that Victoria Foster was the leader in this situation. She's the one that left clear instructions that specified to Mr. Rimson what to feed this child and when, and it was taped on the wall, which demonstrates to me that Mr. Rimson was in some respects following the instructions of the person who was the mother of this child. I think she was the mother, she was the leader, and so I'm not scoring it for Mr. Rimson. But your position is duly preserved for the record, Mr. Woodard. Offense variable 16 and 17 do not apply. Do you all agree?
I agree.
Yes.
Offense variable 18 does not apply as well.
Yes. Correct.
Offense variable 19, threat to security of penal institution or court or interference with the administration of justice or rendering of emergency services, scored at 0. Your positions?
I agree.
I don't have anything to offer, Judge.
Okay.
It will be 19.
I think offense variable 19 should be scored at 10 points. The reason I believe offense variable 19 should be scored at 10 points is Mr. Rimson said over and over that the reason that he didn't send the child to school, he didn't send the child to daycare, he didn't take the child to the hospital, is because he didn't want to get in trouble. That people would think that he was abusing Manny if they saw him the way that he was. And I think the fact that he evidenced if this child had been seen by outside people such as hospitals, school officials, anyone like that, mandatory reporters of child abuse, that he would have gotten in trouble because they would have suspected he was abusing Manny the way he looked. I think that to me demonstrates that he was attempting to interfere with the administration of justice by preventing the child from being seen by people who would have reported it to the appropriate authorities. So, despite the position of both the prosecutor and the defense attorney, I am scoring offense variable 19 at 10 points.
I don't know if I stated, but I think it should be 0 points. I don't know if I said that already.
You did.
Thank you, Judge.
Okay, and offense variable 20, there was no terrorism here. Do you all agree?
I do.
Yes.
Okay. So, not barring any of the objections that you all have placed, with offense variable, the court deciding offense variable 3 should be 100, and offense variable 4 should be 10, offense variable 6 should be 10, offense variable 7 should be 50, offense variable 10 should be 10, and offense variable 19 should be 10. That changes his OV score from 121 to 190. Do you all agree, not waiving your objections?
I agree.
I'll take the courts. I didn't add it up because did you also take off the 10 points for OV1 and 1 point for OV2?
Yes, sir.
Okay.
All right. And we're on the C grid, is that correct?
Yes, Your Honor.
With a PRV score of 10 points, that makes him a level C. And with an OV score of 190, that makes him a level 6. Do you all agree?
Yes.
That is correct.
Which means his guidelines they remain the same as the pre-sentence report had him scored at 43 to 86 months. Is that correct?
Yes.
All right. There's no one here that wishes to speak on behalf of this child. Is that correct?
Just me.
All right. What would you like to say, Mr. Woodard?
May I address what my recommendation is for sentencing?
Yes.
And the reasons for that also?
Yes.
Okay. Judge, the guideline range in this case, as the court knows, after Lockridge has been decided, is advisory. I believe that an appropriate sentence in this particular case, and I'll articulate why I think it is that, is 120 months to 180 months, 10 years to 15 years. Under the case of Steenhouse, Teanhouse. That's a Michigan Court of Appeals case that was just decided last week, interpreting Lockridge. The focus of Steenhouse, for purposes of today's discussion, is on the question of what reasonable means under Lockridge, and under the determination has been made, and it's a public case, Steenhouse's, that the question has to do with the seriousness of the offense, factors not considered by the guidelines, such as the relationship between the victim and the defendant, and factors that are inadequately considered by the guidelines in a particular case. Judge, I think one of the factors that's not adequately considered by the guidelines, and which I think reflects or should influence this court's decision, is the relationship that Mr. Rimson had to this little boy, of caregiver, of the sole lifeline to the outside world. I recognize what the court has said about Ms. Foster, and of course I have arguments to make when she's sentenced, but for Mr. Rimson's purposes, on a day-to-day basis, he was this child's window to the world, and he served to do nothing but, diminish this child's opportunities. And I think that fact is not considered in the guidelines, and I think that it's an extremely persuasive and probative fact for the court's considerations. I think that if the court gives that factor the weight I believe it deserves, it would arrive at a conclusion that a sentence of 10 years to 15 years is proportional, both to the nature of the offense, the relationship of the defendant to the victim, and the seriousness of this offense. So that's what I would ask for, Judge. And the court did notice that there's no one here to speak on behalf of Emmanuel Foster. And I think that, unfortunately, that's a pattern that was begun a long time ago. And so, Emmanuel's not a person that I'll forget anytime soon. I hope that the people that he touched won't forget either.
Okay. Mr. Brown, is there anything you'd like to say on your client's behalf?
Yes, Your Honor. I think that the jury worked very hard and examined the evidence and came up with a verdict that probably reflected what occurred. I think that there are guidelines because there's to give guidance, to give some kind of indication of what would be an appropriate sentence. We all know, the prosecutor knows, I know, that you can give 2/3. You can give him 10 years. It's the maximum on this case because it's a 15-year case. But I think that we should consider the fact that, just looking at this prior record variable score here, there's nothing. There's 10 points because there's 2 convictions. There's nothing. That means Mr. Rimson is, I'm not giving him a pass because he's 28 or 29 years old, but he hasn't had a connection with the criminal justice system. I think that Mr. Rimson, notwithstanding what anybody else thinks, was really doing his best. I think the court said something earlier about people do the best they can given their circumstances earlier in the assessing the guidelines. I really believe that Mr. Rimson was doing the best that he could do. I was struck by something that maybe not be important to anybody else, but it was important to me that he said in his, really his testimony, his statement that he gave to the police was his testimony, that when they were saying, are the lights on? He's like, no, I went and got the lights on because I wanted to, I wanted to give them some place to stay. The children were with their mother. This is not casting any aspersions on Ms. Victoria. I'm not casting anything on her. I'm saying, though, but people do the best they can do given the circumstances they can. They might not do what you would do or I would do or somebody else would do, but the best they can do. I understand throughout, and I'm saying this because I respect you, but I disagree with you about a lot of things. But I think that the overriding thought that you talked about beating the child for a piece of bread, he disciplined the child. He did discipline the child, and people get disciplined for different things. Throughout this trial, there's no evidence of him beating the child. That he spanked the child. That's what they said. And all those bruises and lesions, the doctors didn't say that's because, Dr. Schmidt said it could have been this, it could have been that. But there's never any conclusion that this is what it is, like there was an inflicted injury based upon testimony or any kind of evidence based upon what Mr. Rimson did. I understand The court, you may disagree with me, and obviously you can do whatever you want to do, because the guidelines don't, you're not governed by the guidelines, you are governed by the 2/3 rule. But I think that it would be inappropriate to go outside the guidelines in this manner. I'd ask for a sentence within the guidelines. Thank you.
Okay. Mr. Rimson, is there anything you'd like to say on your own behalf, sir? Recognizing that you have a right to automatic appellate review of your conviction because you were convicted by a jury, I certainly don't expect you to say anything that might, affect your ability to appeal. But if you would like to say something, you may.
Yes, ma'am. First and foremost, I just want to somewhat extend my deepest apologies and sympathy for this entire situation. This is nothing I really intend to purposely put anybody through. But people who really know me know that I'm not this person. But I never cried so hard in all my life the day Manny passed away, and there will never be a time where I won't miss him or I won't think about him. It changed me mentally to look at things from a different perspective and a different way of life, and I just really want to say that I'm sorry to his family that they really had to endure this situation, this tragedy. It hurts me, but I know I don't hurt like they do.
Okay, well, thank you for that, Mr. Rimson. I really feel as if you were put in an impossible situation to a certain extent. I really believe strongly that Victoria Foster knew that Manny was near death and left you to hold the bag. You might not feel that way, but I feel that way. And that's based upon the evidence that I saw. I mean, it just doesn't make sense. But, I don't know what would have happened if you had decided to take little Manny to the hospital instead of trying to treat him and care for him yourself. I don't know. But the part that's most troubling about this to me, and I think that people spank children for a lot of different reasons, and there's a lot of different opinions as to whether or not corporal punishment is appropriate for a child. But for a child to be spanked because he took a piece of bread and lied about it, your sister testified, and she said at one point that he was spanked because he lied, but at another point she said that he was spanked because he stole an object. And it wasn't until it came out that the object that he stole was a piece of bread that she said, well, that he spanked him because he lied, not because of what he took. And, you talked a lot in your statement about the fact that Manny was always eating raw food. He was known to sneak food and eat food. And that's because that baby was hungry. He was hungry. He was hungry. And it doesn't matter, what instructions you were left by his mom. You're a smart person. And in the time that I've come to, and I'm not even pretending that I know you because I don't, but this case has been in front of me for a long time, and you've written a lot of things on your own behalf. You've expressed yourself, and it's clear to me that you're very intelligent. You're very intelligent. So it seems to me as if you knew better. You knew better, and you could have done better, and you chose not to. Now the jury has spoken, and their verdict is final. I don't necessarily agree with the decision that they reached, but it's not my job to undo the verdict that the jury reached. I don't think this is a situation where, as it relates to Manny, you simply didn't really know any better. I think that you knew in your instincts, everything inside of you told you that Manny needed to go to the hospital, and you said it in your own words, and that you decided not to do it for whatever reason. Either it was because you were afraid of getting in trouble, which is what I believe, or it's because you were just doing what his mom told you to do. Right is right and wrong is wrong, and you have other children. You have another child that wasn't involved in this case at all, and you have your daughter who was your co-defendant's child, and you're a relatively young man, and when you get out of prison, you'll still be young, and you'll have the opportunity to be a father again if you choose to, and I hope to God that you have learned something from this, and that you will never, ever, ever put yourself or put another child that's left in your care in this situation. So it's the sentence of this court that you will be remanded to the Michigan Department of Corrections for no less than 10, no more than 15 years for the count of involuntary manslaughter. And for the count of child abuse in the second degree, your sentence will be 5 to 10 years, and that will run concurrent with the time that you're serving for homicide and voluntary manslaughter. You have 383 days credit from the time you were arrested until the time of this conviction. You have to pay $60 in DNA fees, $68 in state costs, a crime victim's assessment of $130, court costs in the amount of $1,300, and attorney's fees in the amount of $600. I think that Mr. Brown did a very good job on your behalf. He was able to, present a theory to the jury, even though he's not obligated to do anything. I think he put on a very good defense for you, and you have him to thank for this verdict that you received. So you have 42 days from today's date to appeal your conviction to a higher court. If you cannot afford an attorney, one will be appointed for you, but you have to notify us in writing within 42 days of today's date. I believe you've already been handed the form and reviewed it. That's the notice of your appellate rights. But once you have read it and understood it, you should sign it if there's nothing further. Did I say the day's credit?
Oh, you did not?
Yes.
Oh, 383
I'm sorry, I
days
didn't
credit.
have- I apologize.
Okay. If there's nothing further, that concludes this matter. Good luck
Thank
to
you.
you,
For the
sir.
record, he's acknowledged receipt and execution of the appellate right form.
Okay, great. Thank you.
Thank you, Your Honor.
Bring out Ms. Rimson. Ms. Foster, please. Did you hear me? Okay, I'll let you know. See you. Dawn and her deadly heater down there. Dawn, I'm getting you some beat. I'm planting some beets in your yard.
You're going to plant some?
Mm-hmm. Do I make beet juice where you could just drink it?
Case number 15-1675, People versus Defendant number 2, Victoria Foster. The matter is here today for sentencing.
Appearances for the record, please.
Your Honor, good morning. Michael Woodyard, appearing on behalf of the people.
Good morning, Mr. Woodyard.
Good morning, Judge.
Good morning, Your Honor. Wyatt Harris on behalf of Victoria Foster stands to my right.
Good morning, Mr. Harris, and good morning to you, Ms. Foster. Today is the date and time set for sentencing. Mr. Harris, have you had an opportunity to review the pre-sentence investigation report?
I have, Your Honor.
Are there any additions, corrections, or deletions that you believe need to be made to the body of the report?
No, I did not, Your Honor.
Okay. Mr. Woodyard, is there anything that you believe needs to be corrected?
No, Your Honor.
Okay.
Not that I've observed.
Let's talk about the guidelines then. The PRVs are scored at 20 points, is that correct?
That's correct, Your
I
Honor.
believe that's correct, Judge.
And let's talk about the OVs then. Offense variable 1 is scored at 10 points. That should be 0, is that correct?
I believe it should be 0.
That's correct, Your Honor.
Offense variable 2 is scored at 0, that's correct.
Yes, Your Honor.
Yes.
Offense variable 3 is scored at 100.
I don't believe that that's correct, Your Honor.
Okay, you think it should be what?
I think it should be 25.
Okay, and why?
Because I don't know that involuntary manslaughter is considered a homicide.
Okay. I think, and Mr. Woodard, you
Your-
believe it should be what?
I believe it should be 25, Judge, because of the language in the instruction that it is any crime, and this is the second bullet point, any crime in which the death of a person is an element of the crime is a, quote, homicide, for purposes of offense variable 3. I think that language would control, and it should be 25 points.
Okay, well, I think it should be 100. I think it's properly scored because she was convicted of involuntary manslaughter. Well, you know, I guess it also depends on what you score them for, first of all. I think it could be 100 as score for involuntary manslaughter. I also think it could be scored at 100 if you're scoring the guidelines for the offense of torture, and also if you're scoring the guidelines for child abuse in the first degree. You know, scoring both of those offenses, which I think her guidelines do have to be scored for all three under the circumstances, and I think that 100 points is appropriate to be scored for either of the three. So let's specifically focusing on torture and child abuse, I think it should be 100.
And Judge, if I may, I apologize for interjecting. When I'm not just simply jumping on to what the court said, but my mind was thinking of involuntary manslaughter as the sentencing offense.
Right.
And I think that under that argument it would be 25, but I agree. The top charge is the one we should score, which is either child abuse or torture. They're both life offenses. And Judge, under either of those, 100 points would be appropriate under OV3 because neither of those are, quote, homicide offenses. And I think in both of those cases, obviously, a victim was killed. And so under either of those offenses, and if we proceed scoring in that fashion, I'll readjust my thinking, and I apologize.
I would argue, Your Honor, that in torture and in child abuse, death of a human being is not an element of those particular crimes. And if you look at bullet number 2 in OV3, it specifically identifies death as being an element of one of the crimes. And so if we were looking at it from a torture or a child abuse standpoint, then they should not be scored. It should not be scored at 100 points.
Okay, well, your position is duly noted for the record, but I believe it's scored at 100 points.
Thank you, Your Honor.
You're welcome. Offense variable 4, psychological injury to a victim, scored at 0 points.
I agree that it should be at 0, Your Honor.
Mr. Woodyard?
Your Honor, I believe that it should be scored at 10 points for the reasons that the evidence established that Emmanuel Foster was not in school perhaps ever, but certainly for weeks prior to his death. I think the evidence established that he was in a malnourished state and that he was not adequately cared for. Ms. Foster's statement acknowledged that Emmanuel would be beaten for defecating on himself and urinating on himself, having standard bathroom accidents, that he would be punished for that physically with corporal punishment, and that Mr. Emmanuel Foster had a habit of stealing food and that he was punished for those factors. I think that under all of those circumstances, offense variable 4 would be appropriately scored at 10 points.
Okay, well, under the circumstances, it says, you know, even though this child here is dead and it's not possible for him to seek psychological treatment at this point, I do think that the facts and circumstances of this case clearly demonstrate that any child that was made to live in these conditions that Manny was, beaten for eating food, beaten for defecating on himself, basically starved to death and left to lie in his own waste and develop bed sores, and then on top of it, his mom said she put icy hot on his feet, which under those circumstances would just even make the situation even worse if little Manny could even feel his feet anymore. He was dying from the toes up, from the inside out. And so I think clearly, you know, he would have suffered some psychological injury in the way that he was made to live. I think the evidence supports offense variable 10 being scored at 10 points, and I will score it so, but your objection is noted for the record. Offense variable 5 does not apply. Do you all agree?
Agree.
Yes.
Offense variable 6 also does not apply. Do you all agree?
Agree.
Judge, I think if we're scoring the guidelines for torture or child abuse, it does not. I think if you score it for manslaughter, it would. So under the path that we're undertaking at the moment, I agree it should be 0.
Okay. Offense variable 7 scored at 50 points.
I believe it's appropriate.
Okay.
I believe it's appropriate.
Offense variable 8 does not apply. Do you all agree?
Correct.
Yes.
Offense variable 9 scored at 0 points.
I agree, Your Honor.
Mr. Woodyard?
Judge, I think that evidence established at trial that there were 2 other children who Ms. Foster left in the care of Mr. Rimson, that Ms. Foster knew that Mr. Rimson would physically punish at least one of her children, that he lived in a household that was not adequate for providing the standards of care that the children were entitled to. And I think that under those circumstances, clearly those two children were in danger of physical injury. And I think that's what's required, and I would argue that 10 points is appropriate on OB9.
Okay, well, under the circumstances, I don't really, the evidence, and at the risk of sounding like a broken record, because I said some of this stuff already before for Mr. Rimson, but Ms. Foster is entitled to her own independent review of the guidelines. And I just don't feel that I have enough information to be able to assess the well-being of those girls to know whether or not they were really placed in danger or whether they just simply were left to live in impoverished conditions. And, I don't know whether they had bruises. I don't know whether they were malnourished. I don't know whether they were ever hit or beat. The only evidence that I heard from Mr. Rimson's testimony was that those were his princesses and that they got anything that they wanted and they were spoiled. And so I can't really say, based on the information presented here, that they were ever in danger of physical injury or death. And so I am not going to score offense variable 9.
Thank you, Judge.
Offense variable 10, exploitation of a vulnerable victim. They have that scored at 0 points.
I believe it should be 10, Judge.
I believe it should be 0, Your Honor.
Why do you believe it should be 0, Mr. Harris?
Your Honor, I don't believe that there was any exploitation of Manny on the part of his mom. I don't think that she was trying to exploit this child. I think she was doing her level best to try to care for this child, and maybe she exhibited some lack of knowledge in doing and trying to care for this child, but I don't believe it rises to the level of exploitation.
Okay, Mr. Woodyard.
The instruction also contemplates that an offender abused his or her authority status, and a parent is listed as an example of an authority figure right in the instruction. Judge, I think that clearly Ms. Foster, the biological parent of the deceased child, abused that authority status by causing the child to live under the circumstances that he was living. And I'm not referring to poverty, I'm referring to the nature of the abuse that he was undergoing, the nature of the physical ailments that he suffered from, and the fact that with Ms. Foster's knowledge, Emmanuel was deprived necessary medical care. I think that all of those things certainly add up to an abuse of authority status, and 10 points would be appropriate.
I agree, Mr. Woodyard. I think under the facts and evidence presented in this case, clearly you have a parent that, I don't even know if you can call her that, but you have a woman who birthed a child, and she abused it in every respect, her responsibilities to this child. She left him without proper food. She left instructions to feed him and basically, I believe what Ms. Foster did is she set up her own in-home hospice care and just gave this young man the bare necessities until, he was supposed to be given Insure, and he was supposed to be given something for pain, which is basically what you do to somebody in hospice. You give them the bare minimum to make them comfortable until they die. And the only way she was able to do that and put him in this situation was by exploitation of her role as his parent. And so I believe that offense variable 10 should be scored at 10 points. But your objection is duly noted for the record. Offense variable 11 doesn't apply. Do you all agree?
Yes.
Agreed.
Offense variable 12 also
Agreed.
does not apply.
Yes.
Offense variable 13, there's no evidence that this was a continuing pattern of behavior. So that should be 0. You
Yes.
all agree? Offense variable 14, offender's role in a multiple offender situation.
Judge, it's scored at 0. I believe it should be scored at 10 points.
Why?
I spoke to Mr. Harris about this before we went on the record. Judge, I believe that under the facts of this case, Ms. Foster bears the responsibility as the biological parent of the deceased. As the court pointed out, there were these written instructions that were left behind. There was Ms. Foster's voluntarily absenting herself and leaving the child in what the courts described as hospice. I hadn't thought of that term. I hadn't thought to describe it in that way, but I agree. I think that's certainly what the evidence shows, and it's clearly a circumstance that was at Ms. Foster's design. It was clearly with her knowledge, and I think that she, because she is the biological parent of the child, was driving the bus on this one, and I think that she's responsible.
Well, I think if you use her being a parent as an issue to say that she was the leader in this particular role, when you look at what she did or tried to do as a parent, she left instructions for Mr. Rimson to care for the child. And she did return to the location on several occasions to care for the child. There was no intent on her part to commit torture. There was no intent on her part to commit child abuse. And when you consider that you consider the entire criminal transaction when determining the offender's role, there is no evidence on this record that she played a leading role in trying to commit torture, child abuse, or involuntary manslaughter. So that's why I would ask this court to score it at 0.
Okay. Well, I think, under the evidence that's presented here, I think it's very clear to me that Ms. Foster was the leader. She set it all up. She's the one who made the arrangements to decide that her and her children were going to move into that house with Mr. Rimson. She's the one that decided to absent herself and go to Saginaw to work at Wendy's when, I'm sure there's any number of places that she could have chose to work around here similar, but the real issue was she wanted a better life for herself. She wanted a better life for herself, and that's why she chose to leave the Detroit area and leave her child behind with these archaic, barbaric instructions on how to care for a child. I mean, it defies all common sense, logic, and reason to think that this is the way that you were supposed to care for this child. I think she was the leader, and I believe offense variable 14 should be scored at 10 points. Your objections noted for the record. Offense variable 16 does not apply. Do you all agree?
Agree.
Yes.
Offense variable 17 also does not apply. Do you all agree?
Agree.
Offense variable 18 does not apply.
Yes.
Agree.
Offense variable 19, threat to security of a penal institutional court or interference with the administration of justice or rendering of emergency services.
I believe that it's properly scored at 0, Your Honor.
Okay. Mr. Woodyer.
Your Honor, in this case, the evidence showed that Ms. Foster was aware that Mr. Emmanuel Foster needed medical care, that he needed attention from professionals, and she declined to get it, declined to provide him those needed services. In addition, the fact that Mr. Emmanuel Foster wasn't in school for at least the weeks prior to his death, leading up to his death, and the reason that Ms. Foster herself said that she declined to provide that care or those services was for concern for her safety. She knew that had Emmanuel been seen by one of these caregivers, that her other children would have been taken from her, and that the government would have gotten involved, Child Protective Services would have been mobilized, and I think that Ms. Foster's efforts to prevent that from happening amount to an interference with the administration of justice.
I agree, Mr. Woodyer. Under the circumstances in Ms. Rimson's, I'm sorry, I keep doing that, in Ms. Foster's statement, she indicated that she knew that, she was afraid. She didn't say that she knew, but she said she was afraid that her kids would be taken away from her, and she didn't want her kids to be taken away from her, and that's why she didn't seek out medical care for her son. And so under those circumstances, I think that clearly demonstrates an attempt to interfere with the administration of justice. So I believe offense variable 19 should be scored at 10 points.
Your Honor, may I correct the record?
Sure.
You and the prosecutor both indicated that Ms. Foster has indicated that her children would be taken away from her. Her statement specifically said that she was afraid that he would be taken away from her. Now, I know there's a distinction there, but I want to make sure that the record is correct.
Okay, so you think that he refers to somebody other than her child?
I think that he refers to Emmanuel. I don't think that it refers to her other children.
Oh, okay.
And that's what the court and the prosecutor has expressed, and that's not what's in her statement.
Okay, well, I think the point is still the same, but thank you for correcting that.
Thank
That
you.
if she failed to get him care because she thought he would be taken away from her, that's interfering with the administration of justice, because that's not getting him care so that the appropriate authorities who are required to report abuse and neglect and take children away, Child Protective Services, don't get involved. So I think the point still stands. It still stands for the same principle, that that's interfering with the administration of justice. But thank you for correcting the record to accurately reflect your client's statement. Offense variable 20 also does not apply. Do you all agree? There is no terrorism here.
Correct.
I agree, Your Honor.
Okay, now not waiving any of the objections that you all have placed to my scoring of the guidelines, I believe we are now at
190, Your Honor.
let's see. I was an English major, so I don't add that fast.
I believe it's 190.
100 for offense variable 3, plus 10 for offense variable 4, plus 50 for offense variable 7, plus 10 for offense variable 10, plus 10 for offense variable 14, plus 10 for offense variable 19 is 190. Still a level 6. And we're on the C grid, which means that with a PRV score of 20, it's a C, and with 190, it's a 6, which makes her guidelines. Am I doing that right? No, we're not on the C grid.
We're on the
It's
A
the
grid.
A grid.
Yes.
We're on the A grid, yeah.
It's the C grid for involuntary manslaughter.
Correct.
And it's the A grid for child abuse in the first degree and torture. So her guidelines are 135 to 225. Not waiving your objection, but you agree that that's how I've scored them.
Yes, for torture and for
Child
child
abuse.
abuse in the first degree.
Okay. Mr. Woodyard, I know that is there anyone here who wishes to speak on behalf of Manny?
Judge, the only person in the audience is Ms. Foster's family member, who that would make him also, of course, Emmanuel's family member. I know that Ms. Foster's uncle, his statements are reflected in the pre-sentence investigative report. Can I backtrack just for a second, Judge?
Sure.
In terms of correcting the record or clarifying the record on Ms. Victoria's statement, which was admitted into evidence and considered by the jury, I believe it was People's Exhibit number 3, although please, I may be inaccurate and incorrect on that. But it's Ms. Victoria Foster's written statement on page 3 of 7. She was asked, "Please explain to me why you thought it was better for Emmanuel to be abused rather than CPS take your kids from you?" And she answered, "I have no explanation." I think that clearly my characterization was correct or accurate.
All right.
I just wanted to make sure that that's all out there.
All right.
Judge, as it relates to the sentencing, you had an opportunity to hear this trial and see all of the evidence and consider Ms. Foster's culpability in the death of her son. I believe that she is a responsible party as much or more than the person who was with Emmanuel at the moment of his death. I believe that Ms. Foster's actions irrevocably led to the death of this little boy, and that her actions during his life just simply set that up as a foregone conclusion. And I believe the court should sentence Ms. Foster accordingly, which I believe the fair and just sentence would be at the very top of the guideline range.
All right.
Yeah, I'd ask this court to sentence Ms. Foster to the bottom of the guideline range. I know that the guidelines are advisory to this court. Ms. Foster has endured one hell of a life. She's had children at an early age, and I understand that that's within her control. She endured the death of her mother probably about 6 months earlier, before Emmanuel died. I think her mother was the support system and the grounding for her in terms of helping her to care for the kids and to provide for the kids and provide for Manny. As I said before, when I told the jury, and I'll tell you again, that I don't believe that she had any intent to torture this young child or any intent to commit child abuse. I know that when we think about this whole situation of this child's feet, and we think about her response to the police with regards to his feet, and the fact that she says that she placed icy hot on it, causes all of us, I guess, great concern. But I think, as I told this jury, that we've got to really look at this situation through her eyes and through her abilities and through her mental competency. And I don't think that at any point in time when she placed this icy hot on his feet that she thought come 2 days later this boy would die. Now, yes, negligent, grossly negligent for not getting him to the hospital, as I've explained to her, that's really the issue. Had you taken him to the hospital on that day, we probably wouldn't be standing here under these particular circumstances. Might be standing here on some other circumstances, but for sure we wouldn't be standing here talking about the death of Emmanuel Foster, possibly. And I would ask the court, she understands that she's going to have to go to prison. She understands that there probably was some things that she should have done. I don't believe, and I know this court has stated that she, being a leader, kind of left Mr. Rimson in a situation that she had knowledge that she was going to leave him to care for this child and set him up in that way. I don't believe that was her mindset and her intent. I think her mindset has been, she was in Saginaw before, and it was something that was comfortable to her. When her mother passed away, it made sense to go back to Saginaw and try to work and try to bring these kids to Saginaw. And as I said before, I don't think it was her intent at all to commit torture, to commit any kind of homicide with regards to Manny or child abuse. So with that, I would ask this court to sentence her to the minimum of the guidelines. Thank you.
Okay. Ms. Foster, you have an opportunity to speak if you wish, understanding that you have a right to automatic appellate review of your conviction. And I don't expect you to say anything that would impact your ability to successfully appeal the jury's verdict in this case. But if you want to say something, you can. I'm sorry, did you say no? All right. I'm not surprised. So here's the deal, Ms. Foster. This is the first time that I've seen you show any emotion throughout all of this. And it's shocking to me that you could sit here and look at those pictures of your baby's emaciated body covered with bruises from head to toe, his feet black, rotting and falling off, and sit there stone like a fence. But now today, when faced with your own fate, you want to cry. I don't think you weep at all for Manny. I think you weep for yourself and for your own freedom, because all you cared about was yourself. You left your children behind while you went to Saginaw to work at Wendy's. And I'm in no way demeaning working at fast food restaurants. I think that people get the work that they can get. I think it's legal work. It's good work. And, you know, I think that in some respects they might have better benefits than some people that have white-collar jobs. So I don't mean any disrespect to people who work in the fast food industry. But you don't have to leave your babies to go to Saginaw to work at Wendy's. You could have worked at any Wendy's around here in the metropolitan Detroit area. You left your babies because you were thinking about yourself. And I don't think that there's any way on God's great earth that any reasonable person could conclude that you were doing the best that you could for your children. I just don't. There's too many resources that are available to poor people, especially here in America. There's no reason for a baby to die of starvation, and basically that's what your baby died from. He was so malnourished because all he was living off of was Chef Boyardee ravioli and ramen noodles, that he lacked the basic nourishment that he needed to fight off basically a common cold, which was allowed to turn into pneumonia, which was allowed to turn into sepsis, which was allowed to then rot and destroy his little body. It's sickening. And I think that this condition that little Manny was suffering from, he was suffering from it long before you moved into Cory Rimson's house. And then what did you do? You left a little note with step-by-step instructions on how your child could be made comfortable until he died. Give him Ensure and a fatty meal, and then give him something for his pain. It's disgusting. Do you know how many people in this country would love to have the opportunity to give birth to 3 beautiful children? And look what you did to your baby. Look what you did to your baby. You know, I hope that you never get out of prison while you still have the ability to bear more children. Because I don't think that you're fit to be a mother. I don't think you deserve the right to be able to bear children. You're disgusting. What you did to this child is disgusting. I've seen a lot of things in my life, but I have never seen anything like those images of little Emmanuel. And how you could sit here and look at those pictures of your baby and stay stone-faced and not drop or shed a tear. Even Mr. Rimson shed some tears, but you sat there completely unaffected. But today you want to stand here and cry over yourself. It'll be the sentence of this court that you will be remanded to the Michigan Department of Corrections. Oh, let me say one more thing. Even though I don't have to find a substantial and compelling basis to upward depart from the guidelines because of the recent case law, I do think that clearly the guidelines are inadequate to address the severity of the torture that this child suffered. And you know, what is it going to do to his little sisters that they basically watched their older brother die, and now their mom's been taken away from them, and they don't understand any of this. The guidelines don't in any way, begin to account for the generational impact that your crime is going to have on your daughters. It doesn't in any way begin to account for the fact that if, I don't know what's happening over in the family division as it relates to your parental rights, they should be terminated. And if it was up to me, I would terminate them today, but that's not in my jurisdiction. But, forever those bonds will be broken. What relationship will you have with your daughters? If they have children and they have, you have grandchildren, this crime, and it was a crime, it wasn't just an accident. This crime will have a generational impact for years to come on the generations that will come behind you of the two children that are left living. And so I think that the guidelines are clearly woefully inadequate to address the suffering that little Emmanuel endured at your hands long before he was left to die in the care of Cory Rimson. Also, I'm a little baffled by the jury's decision that they found you guilty of both underlying felonies, but then didn't find you guilty of felony murder. And I think that's due to a very good job by your defense attorney in convincing the jury that they should consider the lesser offenses. I believe, if they had been presented with the crimes just as charged, you probably would have been found guilty of murder in the first degree, because they found you guilty of both of the underlying felonies that go along with felony murder. So I think that you have your attorney, Mr. Harris, and the zealous advocacy that he put forth for you to thank for the verdict and to thank for the fact that I can't put you in prison for the rest of your life, because if I could, I would. So it'll be the sentence of this court that you will be remanded to the Michigan Department of Corrections for no less than 27 years for the accounts of torture and child abuse in the first degree. Your sentence will be 27 to 50 years. And for the crime of involuntary manslaughter, your sentence will be 5 to 15 years. And those sentences will run concurrent. You have 42 days from today's date to seek leave to appeal your conviction to a higher court. You will have 42 days from today's date to seek leave to appeal your conviction. If you can't afford one, you have to notify us in writing. You've been handed a notice of your appellate rights. Once you have read it and understood it, you should sign it. You have 383 days credit from the time of your arrest until the time of this conviction. You have to pay $68 in DNA fees, $130 in crime victims assessment, $1,300 in court costs, and $400 in attorney's fees. It says here that you have to pay $204 in state costs, but that can't be right. It's not $204, is it?
They charge 68 per count.
Oh. Okay, it's $204 because they charge you $68 per count. Yes.
Judge, my client has asked if she could say something to the court.
No, she had her chance. Good luck to you, ma'am. That concludes this matter.
Thank you.
Thank you, Your Honor.
You're welcome.